up. So we decided to kind of pull that bill. So when that happens, it's kind of hard to advance a bill. So we'll start off with bill introductions. I know Whitney Dameron has one for sure.
Thank you, Mr. Chairman, members of the committee. Whitney Dameron on behalf of Kansas Entertainment. 26 RS 3523, a bill on amusement machines related to gambling devices.
Thank you, sir. Any questions or objections to introduction to that bill? Seeing none, that bill's introduced. Thank you, sir. Any other bill introductions? Seeing none, I think we're in pretty good shape. What we're going to do today is we've got 3 bills to work, and we'll take the easiest first and work our way up the chain. So first we'll hear Senate Bill 392 and have Jason give us a quick review of that.
Mr. Chairman and members of the committee, Senate Bill 392 is the bill making amendments to various election statutes to provide for when a candidate may withdraw their candidacy for elected office. It provides for withdrawal due to severe medical hardship that has been signed by the physician on that certification. Also, the candidate may withdraw upon certifying that they no longer reside in the district for which they filed as a candidate. If the certification is received by September 1st, then the candidate's name would be withdrawn and not printed on the general election ballot. Additionally, if the candidate dies before September 1st, then their name would be withdrawn and not printed on the ballot. And finally, the bill addresses vacancies in a joint candidacy for governor and lieutenant governor. If a vacancy occurs for any reason, including withdrawal of a candidate, then the joint candidacy would be terminated under Senate Bill 392, and any remaining candidate would have to refile a new joint candidacy for those offices.
Any questions, committee, on this one? Do I hear a motion? Senator Blue?
Thank you, Mr. Chair. I move that we pass out Senate Bill 392 favorably for passage.
Is there a second? Second by Senator Gossage. Any further discussion? Seeing none, and this is Senate Bill 392 on the vacancies. Okay, very good. All those in favor, we have a motion by Senator Blue, second by Senator Gossage. All those in favor say aye.
Aye.
All those opposed, no. That one appears to pass, so we're in pretty good shape there. Next, we'll move on to Senate Bill 394 and have Jason give us the quick overview of that one.
Yes, Mr. Chairman, Senate Bill 394 is a bill that would amend KSA 25-1121 to add provisions to allow for assistance in filling out an advance voter ballot. In addition to if the voter is physically unable to sign the envelope, if the voter is unable to sign the envelope consistent with the signature that is on file in the voter registration database, then the voter can also receive assistance in completing and mailing their ballot, and the individual assisting them would sign the envelope, including the affidavit statement on that envelope. The other part of Senate Bill 394 would enact a conditional repealer of all advance voting ballot statutes. If the provision for signature verification in 25-1124H is ruled unconstitutional or is enjoined by a final order or judgment that's not subject to appeal, then such decision is to be published in the Kansas Register, and upon such publication, then the statutes that provide for advance voting by mail in Kansas will be repealed, and it will no longer be an option in the state of Kansas.
And I might note, in conversations with the Secretary of State's office and with Clay Barker, he noted there is a federal judicial rule called the Purcell Principle that courts should not change election rules during the period of time just prior to an election, because doing so would confuse voters and create problems for officials administering elections. And I think that is for federal law. And I do believe we have an amendment that kind of addresses our situation here in Kansas. And I'll have Jason pass that out. Thank you, sir. And I'll let you explain the effect of this, this amendment, Jason.
Yes, Mr. Chairman, members of the committee, the balloon amendment for Senate Bill 394 that was just handed out would create a separate conditional publication date for any final order or judgment on the provisions of the signature verification requirements, so that if the final order or judgment is issued within 30 days prior to the date of an election, or if it is issued at any time from that date of election until the results of the election are certified by the Secretary of State, then the notice of the final order or judgment would not be published until the next regular publication of the Kansas Register following the date the results of the election are certified by the Secretary. And so it would just ensure that the notice and then, as a fact, the repeal would not go into effect until after the election results had been certified by the Secretary of State.
Okay. Any questions, committee? Senator Fasquedo?
Thank you. Thank you, Mr. Chairman. So, Jason, how did we determine that judgment would be made, and what were the dates on that? Thank you.
Mr. Chairman, members of the committee, so the new section 1 directs the Secretary of State to monitor litigation challenging the validity of the signature verification requirement. And so the Secretary of State would monitor whether or not a final order or judgment that invalidates or enjoins enforcement of that requirement had been issued by a court in a non-appealable order.
Sure.
Thank you, Mr. Chairman. Jason, so again, how is that data collected for the judge to make that decision? Well, so the Secretary of State will monitor, and they're monitoring from information received by election offices?
Mr. Chairman, all legal challenges and lawsuits, particularly those challenging the constitutionality of a state statute, are public records. And so I believe the legal counsel for the Secretary of State's office would have a system in place to monitor litigation challenging that provision.
Senator Francisco.
Thank you, Mr. Chair. I very much appreciate your work on this, our revisor's work, and from the Secretary of State. My concern is now with 30 days. I mean, I think this wording helps, but if we talk about 30 days, and I can check with our county clerk, but they are sending out notices for people to get an advance ballot. And so my concern now would be to have some understanding of when those are sent out, because you don't want to have sent out the request. Do you want to sign up for an advance ballot and then not be able to count that ballot? So does that make sense?
It makes sense. I think, and when I asked this, it was Clay Barker about this, I said, you know, where do we draw the line? Where's the clear spot to draw the line? And he felt like 30 days was sufficient, because if there was a court that ruled that signature verification was, you know, illegal, and that and because they're intertwined with how we do our election law here in the state, that obviously, you know, the ballot, advanced ballot requests would be out there, but obviously then they just wouldn't accept them, because the signature verification would be null and void at that point. Now, could we discuss whether to make it 45 days? I would be open to that. I mean, military, UACOV is 45, but I don't think I think they have an exemption on that. So, you know, I could live with 45 days to give them some extra notice time. And I suspect the Secretary of State's office would be okay with that, but I'm not sure we'd want to go too much farther beyond that.
Thank you, Mr. Chair. I would appreciate a change from 30 to 45, and then I'm guessing this will probably come out of committee, and when it's discussed on the floor, I will have some more information from our county clerk and have shared that with you before that time.
Okay, I appreciate that. Committee, any discussion, any questions? So are we making a conceptual amendment to change the 30 to 45 days? A substitute conceptual amendment, I guess.
Well, we have this amendment before us.
Yes.
And so I would say that we're discussing this amendment, and I'm just suggesting that we change it to 45 days and then have a motion on the amendment.
Okay. Committee, any discussion on that? I guess the motion would be to amend the amendment, or just a motion to accept the movement. Okay, okay, that'll be the motion. Yeah, so I'll move my amendment, change the days from 30 to 45 days, and leave it at that. We have a second by Senator Francisco. Sorry, I got a little confused myself there what motion to make. So any further discussion? Seeing none, all those in favor of this amendment say aye. All those opposed, no. We're back on the base bill. Any further discussion? Senator Dietrich.
Thank you, Mr. Chair. I just wanted to ask a quick question about, I know we're talking about mailing ballots and signatures, but what about drop boxes? Where are they in this mix?
This would not affect drop boxes at all. This is basically signature verification, yes, and all the requirements that go with that.
Okay.
Unless I'm wrong, Jason, speak up, please.
Mr. Chairman, members of the committee, so the use of a drop box is for the return of an advanced voting ballot to the county election office. And so if advanced voting ballot statutes are repealed and that is not a permissible way to return to vote in Kansas, you would not have drop boxes in Kansas.
May I?
Go right
ask
ahead.
one
Yeah,
more
sure.
clarifying question just to make sure I understand this, because I will be getting emails. So my next question is, if this signature thing is invalidated, we've got the drop boxes that would no longer be available. Then that also means those advanced ballots that go to nursing homes, of which I have 22, they are immobile. They don't leave the building. So they've been allowed to do a ballot and have some family member or a CNA or someone carry no more than 10 ballots to the election office. That will now be null and void, correct?
I believe that's correct, Jason, correct?
Yes, that is correct.
Yes.
All right, thank you. Thank
And
you. for
again, this
clarifying.
is all triggered.
Just in case.
Yeah, this is all conditionally triggered upon a court case that rules signature verification is illegal.
I just want to be able to answer
Yeah.
emails.
I'm sure we would have to adjudicate that in court too, so who knows what kind of a battle that would be. Any other questions? Senator Fasquedo.
Thank you, Mr. Chairman. Jason, this doesn't affect those individuals who are permanently disabled or senior citizens, does it? And they are already on the permanent list to receive an advance ballot. Does it affect them?
Mr. Chairman, yes.
How?
Though that permanent list is part of the advanced voting ballot statutes that would be repealed under this conditional repealer. There would be no mechanism to vote in advance by mailing or returning a ballot to the county election officer if the statutes are repealed.
Wow.
Again, if a court case ruled that signature verification was illegal, then it would trigger all of these things. It'd be a domino effect. So, yeah. So, any further questions? Seeing none, is there a motion on this bill? Senator Blue?
Thank you, Mr. Chair. I move that we pass out Senate Bill 394 favorably as amended.
Is there a second? Second by Senator Murphy. Any further discussion? Seeing none, all those in favor say aye.
Aye.
All those opposed, no? Okay. Thank you. Do you want that recorded? Okay, very good. Now, that passes and heads to the floor. Our final bill we're going to work this morning is Senate Bill 451, having to do with the Campaign Finance Act, and I'll have Jason give us a quick brief on that.
Yes, Mr. Chairman, members of the committee, Senate Bill 451 amended the campaign finance reporting statute 25-4148 regarding reporting of expenditures for what are essentially sub-vendors of a campaign expenditure. So when expenditures are made to an advertising agency, public relations firm, or political consultant, and then are further dispersed by one of those vendors to another vendor, the vendor's name and the amount and date of purpose of the payment is required on the treasurer's report under current law. Under Senate Bill 451, it would modify that so that the sub-vendor name would no longer show up on the report. It would simply be the products and services provided by that sub-vendor and the date and purpose of the payment.
Questions on this bill? I think Senator Francisco had a discussion on that yesterday, that I think was pretty good, so.
Thank you, Mr. Chair, and I hope it will be looked favorably to make a conceptual amendment on page 2 of the bill, line 22, to strike the words "in detail." And I think we discussed that yesterday, if anyone has any questions.
I don't think that changes materially, alters the bill in any way. Any discussion on that? On page 2, line 22, say the report of such expenditure shall show, it says in detail, the in detail would be stricken, so it would read, the report of such expenditure shall show products and services provided by each such vendor, including the date and purchase. Yeah. Want to move your amendment? We do need a second. Second by Senator Murphy. And any further discussion? Seeing none on the amendment, all those in favor say aye. All those opposed, no. So we're back on the base bill. Any further discussion? Senator Faust-Cadeau.
Thank you, Mr. Chairman. So just for clarification and for those listening in, perhaps our treasurers or anyone that deals with this, so you're saying that we don't have to list that I got 52 yellow balloons, or do I just list the subcontractor person who provided my 52 yellow balloons?
No, you wouldn't have to list the sub-vendors. You would list the primary vendor, like, you work with them, and then they might go out and buy balloons from somebody else. There's no need to go down that rabbit hole and list all of these sub-vendors that your primary vendor works with.
And Mr. Chairman and Jason, so we were already on our reports listing some form of this, but we're clarifying existing law, or we're changing exactly what? If my treasurer asks me.
Jason.
Yes, Mr. Chairman, members of the committee. So currently, you would report the sub-vendor name, the amount of the expenditure, the date, and the purpose of the payment under current law. Under the bill, you would instead just report what products and services were provided and include the date that the payment was made and the purpose of the expenditure.
Should make it easier.
Thank you, Mr. Chairman. And this will be then reflected from our new ethics. What's the name of our new ethics and commission?
Disclosure Commission, yes.
So our treasurers will get another little pamphlet in the mail explaining this new change if it passes into law.
Jason.
I would defer to the commission on their intents on implementing the provisions of this, but I would assume they would adjust their forms and whatever other guidance to conform with law.
I think that's correct. Any further discussion? Seeing none, is there a motion on this bill? Senator Blue,
Thank you, Mr. Chair. I move that we pass out Senate Bill 451 favorably as amended.
a second? Second by Senator Francisco. Any further discussion? Seeing none, all those in favor say aye. Aye. Those opposed, no. That heads to the floor. Committee, that's our work for today. We will have a fairly interesting bill tomorrow. Senate Bill 452, might have a packed house, be ready for that. And then no meeting on Friday. Monday, any outstanding bills that we may have to work, I'm just planning that for a work day since we're heading to the floor for most of the rest of the week. Thought that would be the smartest use of our time. Thank you very much for your work today, and we are adjourned.